Webinar on best practices of a trustee, how not to get sued. Thank you all for joining us. This is going to be a really fun presentation. I'm Samantha Fitzgerald. I am the owner and founder of SJF Law Group, a trust and estates law firm in Plantation. I imagine most of you know who I am. We have some special guests with us today from Fiduciary Trust International. I'm going to introduce them in just a second, but I just want to explain a couple of things in advance. So we have a chat feature. So if anybody has any questions, please feel free to put them in the chat at any time. We love questions. If you think of anything after the fact, or you, for whatever reason, are afraid to ask during the webinar, you can always contact us after the fact. So don't be shy. We love questions. It makes it more interactive. So we're going to start this off with a couple of polls. Jenny, who is my amazing marketing director here on the webinar, she released a couple of polls. So we're going to see how many of you have ever served in the role of trustee and how many of you have your own trust. Let's see. So we've got 50-50 so far on do you have your own trust? 3 yes, 2 no, 1 unsure. Okay, we need to talk. And you've served in the role of trustee. 2 yes, 3 no. Okay, so the 2 that have served as trustee, you know will hopefully appreciate some of this, and hopefully not look back and say, "Oops, I broke the law." Good thing I didn't get sued. So trustees are fiduciaries. They are held to a very high standard of care. What does fiduciary mean? It basically means, it can mean a lot of different things depending on what context you're in, but it means that you're looking at like a best interest standard. That means that you are in a position of trust and you're doing something for somebody else's best interest. So it's very easy to kind of run afoul of the rules doing that. The most common thing that people do is they name their family members or their friends as trustees in their trust, but there's other options too. So without getting into a lot of explanation on what it means, another option is a corporate trustee. And a corporate trustee is typically a financial institution that's authorized by law to serve in the role as trustee, because not every financial institution is allowed to do that. This institution will then appoint people that work there to actually serve in the role of trustee. And when you work with a corporate trustee, you often get a whole team of professional people. They're not all trustees necessarily, but they all work in that capacity as your trustee. So you get a whole team of people, not just one person that might not understand what they're doing. So the purpose of today's webinar is to discuss some best practices from a professional's perspective, since a lot of people out there who are serving as trustee have never done it before, may not ever do it again, don't really know what they're doing. They've never been given any training or guidance. They might not realize that they should be hiring a lawyer and they're really out there on their own. They may have no financial background at all, right? You might be a plumber and your uncle has designated you as trustee of his trust, and all of a sudden, bam, one day you're a trustee and you're expected to read this legal document and figure out how to make distributions to beneficiaries. And along the way, you may do something wrong. You may breach your fiduciary duty, which could encompass things such as self-dealing, have a conflict of interest. That could really catch people off guard. Neglecting the trust terms. You may be guilty of financial mismanagement, which means you might commingle personal assets with trust assets. You may fail to provide beneficiaries with necessary information or distributions. So lots of things can go wrong if you're not sure what you're supposed to be doing. So today I have some amazing guests who are colleagues of mine. They work for Fiduciary Trust International, and that part is important because I learned when I was at a Heckerling estate planning conference recently that there is more than one fiduciary trust company. So Fiduciary Trust International is super important. So today on here we have Leticia Hernandez, who is Trust Counsel at Fiduciary Trust International. She's also an attorney. And we have Matt McCann, who's a Wealth Director at Fiduciary Trust. And if his schedule allows, we will have Vaughn Yeager, who is a Senior Trust Officer at Fiduciary Trust International. And I think of him as kind of boots on the ground, right? He's going to be the person that the beneficiary is probably most dealing with. And Leticia is an attorney who can help him with more complex issues that arise, interpretation of the trust document, distributions, and any really complex questions or legal interpretations that might arise. Hopefully I got that all right. So welcome, Leticia, welcome, Matt. Thank you both for being here with us.
Thank you, Sam.
Thank you, Sam. Delighted to be here, have the opportunity to address a topic that's important to all of us on this call.
Absolutely. So let's start off. I have like a gazillion questions to ask you guys. So, feel free to add any information that you want in there. We'll be monitoring to see if anybody has any questions. So I'll ask you them as well. So the first thing I kind of want to ask is, somebody dies, Fiduciary Trust International is designated as trustee. What are the first few things that you guys do? What do you look at? What are the first few steps that you take as trustee?
I can start, Matt, if you like.
Sure.
So it's funny you asked me that, Sam, because we had this exact same situation today where someone died. He was a beneficiary of a trust. This is an existing client. And, the first thing we do is really, we're there for the family, right? We have conversations, even if it were a new client, the first thing we'll do is have conversations. What are the immediate needs of the beneficiaries? What are their plans? That type of conversation. It's, what are the immediate expenses that they need our help with? And really understand what the document says, what the grantor intended, because it really is our job as trustees to implement the wishes of the grantor. In looking at the beneficiaries' expenses and what their immediate needs is, we try very early on to discuss a budget with the beneficiaries and whether this budget is realistic, and kind of set expectations going forward in terms of what are the needs, what are the assets producing, where do we need to make adjustments in the investments. So a lot of that is something that we'll do very, very early on when somebody dies and they're a beneficiary of a trust.
And that is one of the benefits of a trust. That's not the focus of our webinar today, but I'm a big fan of trusts. And that's one of the huge benefits of them, is that you can immediately jump in there and start administering the estate, we'll call it, right? When assets need to go through a probate process, boy, that can take quite some time, depending on where you're located. In Florida, even, it's different from county to county, sometimes from judge to judge within a county. But state by state, it's very, very different. But with a trust, somebody dies, you get a death certificate, the trustee accepts the position, and you're off and running. So that's a nice benefit of having the trust.
Sam, I would just add that, understand and follow the trust document. And so think of the trust document as your playbook. It outlines, as Letty said, exactly what you can and can't do. And if you follow it carefully, it protects you and it keeps the beneficiaries happy. So you have to understand and follow that trust document, keep beneficiaries informed. Open communication builds trust, and it prevents disputes. So share regular updates, respond to questions in a timely manner. And I will really emphasize, document everything. Maintain meticulous records of decisions, of investments, all the communications. It protects you if questions come up or arise down the road, and then seek professional advice. Lean on the SAM the law firm. Lean on the legal and tax and financial professionals to help navigate some of these nuances and complexities. And then lastly, invest prudently. You don't have to hit home runs, but you do need to act like a responsible investor, and you have to balance growth and risk, and partnering with experts can help.
Those were some really great points from both of you. I'm a big fan of not only documenting, that's really, really, really important, but what you said, communication. We talk about that just in our office a lot, because you can see when problems arise, it almost always relates back to some sort of breakdown in communication. But we do that when we administer trust here. There's no probate court involved. There's no real documented process. It's kind of us pushing the case along, and the beneficiaries, this is the only trust that they have usually. I mean, maybe not, but so they're just sitting there waiting. Something that takes a certain amount of time on our end, they think should be done in 5 minutes, but there's still a process that we have to go through. So communication is really, 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 really key. When it's quiet, their mind starts wandering and it goes in bad places.
That's right.
But when you communicate with them and give them expectations and realistic expectations, right? Don't say, hey, we're going to make distributions in the next month, when it's really going to take 3, 4, 5, 6, 8 months.
Yeah,
that's really key.
Totally agree. I think a lot of disputes potentially arise from the beneficiaries sort of feeling their way in the dark. And if you have that regular communication and a clear financial report along the way, it goes a long way toward building trust.
Absolutely. Yeah. And so when it's quiet, they might just happen to say, well, I don't really know what's going on. I think I'm getting, taken to the mill. I'm going to go talk to a lawyer. And now you got another lawyer involved. And, sometimes that doesn't go well. You just threw gasoline on the fire there. So what other things aside from, those kind of overall things of communicating and documenting and reading the trust? Of course, that's the first thing you do, right? Is read the trust and see what does it actually say, because they're not all the same. They can be very, very, very different. What are some steps that you have to do as far as like notifying beneficiaries, and some initial steps that you're like maybe required by law to do that a trustee and an average person serving might not know that they're supposed to do?
So we definitely, once we're appointed, we do have to send a notice under Florida law letting them know, our contact information. Here's a copy of the document. I like to early on, disclose what the assets are, how they're going to be invested. I think, communication, like we're all saying, and just being extremely transparent with beneficiaries can avoid a lot of problems down the road. So early on, letting them know, what the assets are. Another big thing that I'm always talking about, it's not just the current beneficiary. We also have to keep the remainder beneficiaries, so the next in line beneficiaries, informed.
So let's talk about that. Yeah. So that means, if a trust says I leave everything to my kids and or my descendants, which is more common, or my issue or something like that, the first line is going to be my kids. But then when the kids pass away, it's going to be their children. So you're saying that you have to inform both the kids and the grandkids.
Yeah, if it's a trust that cannot be changed, that's correct. If it's an irrevocable trust. And I get, a lot of pushback when I tell the current client, oh, what do you mean? Because it could have been, someone created a trust for me, and now I have to inform my child, who is maybe 18 or 19, about, this money in this trust. And I get a lot of pushback, but we are required by Florida law, unless there's somebody designated in the document to give notices to inform those beneficiaries. So I see that a lot, Sam, and it's a big problem. There is, under Florida law, there are ways of avoiding that, but I rarely see that built into the document.
Yeah, it's interesting you bring that up, because I was just looking at that rule within the last couple of months, because I had a client wanting to do some tax planning. So they would be creating an irrevocable trust. And I said, well, you're going to have to immediately notify your kids of this trust. And he said, no way. right?
Right.
They'll stop working. They're young adults. No way am I telling them how much money we have. So I said, let me see if there's another option. And I, did some research and found out there is this way to designate. We don't think of it as much when we're just doing kind of basic estate planning because the client's still alive and we're doing things so far out into the future. So we don't think of doing that. But if somebody's setting up an irrevocable trust now, it's a great thing to add in if you don't want to have to notice people. So what we're talking about here is, instead of having to give, let's say, the kids or the grandkids actual notice of the trust and annual accountings and things like that, you could actually put a name in a document and say, instead, we're going to keep it secret. And this person is going to be like their representative. And we're going to notify this person instead. They're going to be like their agent to receive notices on their behalf. It's a really, really cool rule when it's used. But like you say, it's very rarely used. But it's very, very cool. It's a great tool to have in the toolbox. Now, trusts that exist could potentially be decanted or modified, perhaps, to add something like that in. So that could be, something to throw out there as well, if it's that important to do, right?
Yeah, I'll just say, like, it is shocking to people when they hear that they have to. And a lot of the individual trustees don't realize this, right? And unless you're disclosing to those beneficiaries, you can, have problems for many years to come because they never knew of the document. So it could be an investment that was maybe done 20 years ago that they didn't know of, and the statute hasn't run because they didn't know. So that's why unless you give them the information, unless you know who to give the information to, it could be a big problem down the road.
Yeah. And that goes back to the term fiduciary, and that the trustee is a fiduciary and they're acting in the best interests of the beneficiaries, which means the beneficiaries have a right to know what's going on. They have a right to know that they're a beneficiary of the trust. They have a right to know who the trustee is and how to contact them. They have a right to know, what are the assets in this trust? What are they invested in? What am I entitled to? I've seen a lot of trustees not get proper legal guidance and do the wrong thing and keep people in the dark. We get a lot of calls. I think I'm a trustee, a beneficiary of a trust, but I don't have a copy of the trust. It's very interesting. And because there is no court involvement, and there's, unless somebody tells the trustee or they think about it on their own to go hire legal counsel, they don't even know that they're supposed to do that necessarily. And maybe they think that they have to pay for it themselves, but the lawyer that the trustee hires is paid for by the trust assets. So it's just flat out silly and risky for a trustee not to hire a lawyer to give them legal guidance.
Samantha, that's such an important part of what we do. We make time to meet with beneficiaries, understand their concerns, and walk them through the trust terms in plain language.
Right.
And we also offer educational sessions to help them better understand the trust administration and what their specific role is. And so it's really clear that we ensure beneficiaries feel heard, that they're involved, that there's clear communication, and show the beneficiaries that their perspectives matter, while balancing the grantor, the person who set the trust up, also known as the trustor or the settlor. Just remember the or suffix. That's the person creating the trust. Whatever that intent was, you have to balance that out.
Yeah. And that's a good point, and leads me into another question I had for you guys. If the grantor or settlor leaves you some instructions aside from the trust document, obviously you have to follow the trust document, but if they leave you some instructions, or the beneficiaries are asking you or directing you to do things, maybe invest in certain things, or do something specific, within the trust, what do you guys do with that? How do you feel about that? Do you like it? Do you not like it? Do you follow either?
I personally, and I think as a firm as well, love letters of wishes from the grantor. It really helps us to understand what the grantor wanted. Again, the document controls, but it is very, very helpful. And anytime we can, we will certainly have conversations with beneficiaries. Beneficiaries have all sorts of ideas of, what they think we should do with the assets.
That.
And we'll I had someone earlier today had a proposal for a cookie business, and we'll certainly, listen to it. And we don't always say yes, but we do sometimes. And I think it's just important to hear what they have to say, get them involved. And letters of wishes I think are becoming more and more popular. And we certainly do use them. And I personally love the letters of wishes.
We talk to our clients a lot about that, and encourage them to do that, because I prefer, it's our preference as our firm here, we prefer not to put too many specific things in the actual legal document, because it seems good today, but 20 years from now, it's super restrictive, or it's weird, or, it's difficult. So we have our, standard trust distributions. And if something's super important, it goes in the trust, but otherwise leave it for that letter of instruction or letter of wishes, where you can give the trustee guidance, give the trustee discretion and guidance then, to be able to not, get some flexibility. Flexibility is so, so important in these documents that are going to live on for years and years and years.
Yeah, I think there's some, do's and don'ts. We talked about the do's before: understand the document, keep beneficiaries informed, invest prudently, document everything, and seek professional advice. But there's also don'ts. And so what we like to say is, don't play favorites. All beneficiaries should be treated equally and fairly according to the trust terms. Don't mix, if you're a trustee, an individual trustee, don't mix your personal funds and trust funds. Keep everything strictly separate to avoid legal or tax complications. Don't delay distributions. If the trust specifies a timeline for payments, make sure you meet it, unless there's a legally valid reason not to.
Yeah, it's not a fake timeline, right? It's like
not a fake timeline. Yep. And as you said earlier, Samantha, don't make risky investments. Avoid any type of speculative decisions that could potentially jeopardize those assets. And last but not least, don't ignore tax responsibilities. If you fail as an individual trustee to file that tax return properly and timely, it can lead to personal liability.
Yeah. So not only are you in this role, this difficult role, but then you can be personally responsible financially for something that you did. Yeah, that's scary. So touching upon, you said about the investing. So there's this thing called the prudent investor rule, which is a big, long, scary statute, right? So what kind of things do you or don't you invest in? How do you go about deciding what to invest the trust assets in? That's got to be a tough one, I imagine.
Well, I'll start. I think, we have to consider the needs of all the trust beneficiaries. We have to invest to provide regular income, and while making sure we grow and preserve the trust assets for future generations. Letitia, or I call her Letty, referred to that as remainderment. So we have to balance both. We have to have a little bit of income. We have to have a little bit of growth for capital appreciation. So that's usually the first start. But the answer to your question, a long response to a short question, is we sit down, we listen, we take the time, and we have our team come together. We have a professional portfolio manager who will look at the broad aspects of the market, where we think there's value, where we should be weighted, value, growth, stocks, bonds, cash, maybe alternative investments. So it's an ongoing dialogue and process. And Letty, I don't know if you wanted to add anything to that.
No, I think that's great. The only thing I would add is, if there are risky investments, it doesn't mean that we can't take them.
So like the ones like they already exist. So somebody dies and they own some risky assets.
Yeah, and by risky, it could be a business. It could be, a lot of real estate. We see that a lot here. And we potentially could modify the trust where we separate those roles and we make it more of a directed trust, so that we can do our job as trustee and also keep those assets and not have to sell. We don't come on as trustee and immediately say we have to sell all the assets and stick everything in, stocks and bonds. That's not the way we administer trust. We will work with the families and maybe come up with a different trust structure if we can. You mentioned decanting earlier. I mean, there's things that you can do where we can keep the assets, perhaps make it a directed trust, and continue to administer the investable assets.
That's great to know. Interesting. And so if a trust, because we have a lot of clients with real estate.
Mm-hmm.
So if a trust had a whole bunch of real estate rental properties, that's something that fiduciary trust would consider. I mean, you're just not going to across the board keep it or sell it, but it is something that you would consider. And then you have people on your team, or you hire people to help manage those types of assets.
Yeah, and that type of situation, Samantha, it's usually in an entity. So you have already most likely a manager doing a lot of the management, but we certainly would be part of the team and, have conversations with the beneficiaries. What are their intentions with the real estate? Or, some beneficiaries, right, as we know, they just want to sell everything and cash out, but others are interested in continuing to hold the assets. So it's definitely a conversation that we would have and work with the entity manager to keep those assets. And again, it's a case-by-case basis, but it's definitely something that we could handle.
Letty, you mentioned the term a directed trust. Maybe we can just expand a little bit about that, because one of the things that we do really well when there's concentrated assets or unique assets, there's closely held business interests, there's real estate, is we can open up and have fiduciary trust as a directed trustee and appoint a separate investment advisor to direct us with respect to the management of the trust assets, so we can avoid the prudent investor rule about diversification. It's a really unique strategy, and one state in particular, it's all about location with real estate. The same holds true for trust assets, and Delaware has been at the leading forefront of trust law through their Court of Chancery. There's real bricks and mortar down there, and they allow for what they call a Delaware directed trust.
So how do you get the trust in Delaware?
It will just be governed by Delaware law. Okay. And we have an office in Delaware that serves as trustee.
Okay. Yeah, because that's the key, right? Because you can't just pick your law that you want to apply because you like it. There has to be some sort of nexus typically to the state. So
right, exactly.
That's perfect. So yeah, I have heard a lot about the Delaware directed trust laws and how cool they are. So can we explain a little bit like what that means exactly, like in real example of what that might look like?
For the directed trust?
Yeah. Like let's say somebody had a closely held business and we feel like it can continue on. The settlor, the grantor wasn't really a key person in that business. So it's a cash cow. We're going to keep it going, but it's risky from the trustee's perspective because maybe that's the only asset that they owned in the trust.
So as Matt was explaining, the investment advisor who's appointed, they could be appointed by the beneficiaries in the future. It could be somebody appointed by the settlor in the document. They would direct us to hold this item, and we have no choice. If they want to sell the asset and purchase another asset, I mean, they really have all investment authority relating to that asset, and we have no ability to say no. So it's nice because a lot of clients will say, we don't want to be, managing your business, and honestly, they don't want us to be managing their business. So it's a really nice way to segregate the responsibilities where we're worried about the beneficiaries, we're worried about the tax filings, the accountings, who's to get notice, and we do not have to, other than maybe getting a valuation every few years, we have no investment responsibility with regards to that asset.
And when you say investment advisor, you're not necessarily referring to like a financial advisor. It could be any person. It could be their neighbor that's just designated in the trust. They just get this fancy title. And that
Yes.
person basically just gets the power to tell you what to do. And they say, I've got the power. I'm telling you to retain this asset, even though the trust is not diversified, because under Delaware law, those types of trusts exist where they can do that.
Correct. And we
Exactly.
have a new statute here in Florida, undirected trusts as well. I think a lot of trusts will eventually stay in Florida because of this new statute, but it's definitely not as sophisticated and longstanding as Delaware is.
Mm-hmm.
Yeah, I think there's a couple reasons why our clients look to Delaware. One is because that I mentioned the Court of Chancery, and sometimes the terms of a trust can become outdated or no longer serve the needs of the grantor or beneficiary. So in Delaware, the terms of the trust can be changed if the original provisions of the trust prove to be too restrictive or too broad for the family's current circumstances. And Letty referred to this earlier. It's modification. It's called trust decanting. Much like you decant a wine, you can decant a trust. And it's a relatively easy, cost-effective way to update the trust as families' needs change or as their goals evolve. And Delaware really offers a nice path or an alternative path to modify these trust terms via a non-judicial settlement agreement. So there's a lot of flexibility, and Delaware has no limit on how long a trust can last. And so as a result, a trust can last in perpetuity. This means assets held in a trust, including any growth, any income, any appreciation, can pass from one generation to the next, free from gift, estate, and even generation skipping taxes. So a lot of flexibility in Delaware. And we talked about control. That directed trust allows the grantor to split the traditional responsibilities between a trustee and two or more fiduciaries. A lot more flexibility and control when you have those concentrated positions or closely held business interest or real estate or partnership assets, because those can be directed by the investment advisor. The other last one I thought might be helpful is that there's some enhanced privacy and confidentiality. We talked about this earlier, Samantha, that in most states, a trustee has a duty to inform beneficiaries of their interest in a discretionary trust if there's not language that says otherwise. But as you mentioned, grantors may not always want their beneficiaries to know about the extent or the nature of that trust. And so if a parent or a grandparent creates a trust for children or future generations that they fear that the knowledge of significant wealth could undermine their productivity or erode values or otherwise harm rather than help their beneficiaries, Delaware is one of the handful of states that allow, we call them quiet trusts. And a quiet trust limits or restricts the notification to beneficiaries regarding the trust for a specific durational or period of time. And by delaying disclosure of the trust, the beneficiaries can learn about the trust at a time it could potentially have a more constructive impact on their lives. So for those reasons, we like Delaware.
Yeah, that's very, very interesting. And Jenny, if you could add the handout, you mentioned that the trustee has this responsibility, duty to inform, right? The trustee has a lot of responsibilities, and there's a whole list of them depending on where you live. But we have a handout, and I also should have mentioned at the beginning in the handout. So if you guys go to I think it should be on your top right, there's the chat, the polls, and the handouts. All the speaker profiles are there. So if you want to read more about them, all their information is there. And we have a handout Jenny just put up, trustee responsibilities. So you can see all the different responsibilities of a trustee. And there are a lot of them. So it's almost, amazing that every trustee doesn't get sued. How can you do this? How do you know how to do all this stuff? So it's fascinating. So I have a question. I want to ask this HEMS standard. This is a very common distribution standard in a trust. Health, education, maintenance, and support. What the heck does that mean? And how do you guys approach that?
So it's a very broad standard, right? Health, even maintenance. I mean, it's very broad. The first thing I like to do is look at the document, see if there's any other qualifications. Sometimes the document will say to look at the beneficiary's other income. And then, it kind of, we have to make sure that if they're using their funds first, right? And I explain to them, this is, if that language is in there, I like for them to look at it like this is a last resort pot for you to use.
And that's because, these assets are protected, right? So they're in this trust. They're protected usually from creditors and bad spouses and incapacity, disability, all sorts of terrible things. So we want to, if there's no need to take the money out, we'd like to keep it in its protective little bubble as long as possible.
But it's hard sometimes to explain to beneficiaries, this is not their piggy bank, right? Like this is something that was left for you, preserve it, and they don't see it that way. So again, going back to our original conversations with the beneficiaries is key. But if there is a need for medical reasons, for example, we'll have a conversation. We like for them to send us invoices, not just pay bills. So we do look at the invoices. Sometimes if it's maintenance, right? Maybe you need a new roof. We'll ask the beneficiaries for let's get a couple quotes and let's compare. And so it really is just working with the beneficiaries. These are day-to-day conversations that we have with them. Tuition, does that include, that's education. Does that include camp? We get that all the time. Your room and board, what's included. So it's just constant conversation with the beneficiaries and just, what are their long-term plans? We have to make sure, if you don't have other assets, we like to do projections for beneficiaries and really look to see, yes, it's for HEMS, but maybe you're overspending. So again, going back to the beginning, just a lot of communication with the beneficiaries.
Yeah. And you're there to protect them sometimes from themselves. Right. So yeah,
maybe you don't need that car. Maybe you don't need a new car. Maybe, camp. Maybe we should look at other options. It's really is a constant conversation. Of course, it depends on their age as well. We look at their life expectancy, what the trust assets. So it's very difficult, but through conversations, and again, it's daily. We try not to just say no, or we don't just say no. We have conversations with them. We explain to them why, and they get it most of the time.
Yeah. So I often will have clients and they'll have a child that has some sort of problem, drug or alcohol problem. They're a spendthrift, which means, they spend too much money, or they have some sort of issues, and, they may be low on the pool of people that they can appoint as trustee. Of course, that's where a corporate trustee comes into the picture. It's a fantastic option. So I've got two different angles to go here. So sometimes they say, well, okay, so I've got two kids. I want one bad kid, one good kid. I want to name my one good kid as the trustee for the other kid. And we don't like this. We always have a conversation with the client that that's really not a good idea for so many reasons. You're going to put your one child in a very tenuous position, saying yes or no to their sibling, having to make some difficult choices, maybe being pressured. What do you guys see there? How can you help in that situation? I'm sure you see a lot of that. I'm sure you get appointed because of reasons like that. We always, suggest to the client that if you have nobody else, a professional trustee is a great option.
Yeah, and I will say, Samantha, I think if they insist on having a sibling, I would recommend at least to have a co-trustee be a professional. Point. And we have a lot, it's hard. And I tell the clients, let them be siblings, let them work on their relationship. Don't put, one against the other. But I do know a lot of them insist, and we have a lot of situations where we are corporate trustee, co-trustee, and we are the tie-breaking vote. So our say at the end, but that way the siblings stay involved. And I have clients have told me this before, I want them to stay involved in each other's lives. So this is a reason why they do it. But we are a tie-breaking vote, and that does work, and I think gives everybody comfort. I agree it's better just to have a corporate trustee in that situation, but a co-trustee is something that we do often as well.
I love the co-trustee idea. Yeah. And people might not even realize that that is an option
Right.
as well.
Mm-hmm.
So that's
Mm-hmm.
good for everybody to know.
Yeah, I think that approach, having an individual trustee and a corporate trustee, it gives you the strengths of both. Because the individual trustee knows the family history, knows the dynamics, while we handle as a professional the technical, the administrative complexities, the compliance, the investment management. So that approach ensures the trust is well managed. I would also add that if it's an individual trustee, they don't want to work with a corporate fiduciary named in the document, they can hire a trustee as an agent. So we're not named in the document. You retain the control and all the authority, but you can delegate a lot of this off of your shoulders. We can come in to simplify, streamline, reduce some of the complexities, and that's often a very good way to get to the next phase.
That's a great option. So you don't actually serve as trustee, but you're like right there on the sidelines with the trustee, doing all the heavy lifting, the things
That's right.
that they
That's
wouldn't
right.
really know how to do.
Mm-hmm.
Yeah, that's excellent. Um, so another thing when we're suggesting a corporate trustee to our clients, the first thing that they'll say, of course, is, "Oh, they cost money, right? They charge a fee." And I say, "Well, everybody's entitled to a fee. I won't even allow our clients to add language in the trust that says if a relative is serving as trustee, they're not entitled to compensation. Who on earth would want that job?" First, you take a really difficult job, then you might get sued, and then you don't get paid for it. Forget it, right? Sometimes they don't want the fee, and that's fine. That's their choice not to take it. But we always allow everybody to get a fee. So anybody can get a fee. So maybe you can talk a little bit about your fee structure. And, in my opinion, you're no more expensive, and you might be cheaper than somebody else that's serving as trustee. So tell us about pricing a little bit.
Yeah, I'll start. It's a great question. We get that, I'd say 99% of the time, what's it going to cost us? And so the answer is the cost varies depending upon the size and the complexity of the trust. And at fiduciary trust, our fees typically include a percentage-based administration fee for managing the trust and a separate investment management fee when applicable. So we're very competitive in the market, and our goal is to deliver value that exceeds the cost through sound administration, tax efficiency, growth-focused investment strategies, and we're happy to provide a personalized, estimate based on the specifics of your trust. But that's usually the response that I would start with. And Letty, I don't know if you want to add to that.
I'll just add that individual trustees, I feel like it ends up costing the trust more because they have to hire so much outside experts.
Mhm.
Most of the time, individual trustees shouldn't do it without an attorney. We don't, hire outside lawyers unless very limited situations.
And we're
But
expensive.
exactly. They're expensive, hiring, the tax work, doing the accounting. So, it really adds up. So I think that we definitely add a lot of value. And as Matt said, when you look at the fees, it's the value is really, it outweighs. And if we're managing the assets as well, then, it really makes sense because if we're managing the assets for most trusts, the trustee fee is included. There's no separate charge for that. So
That's really incredible because not sure I know of any other trust company that does that. Usually they're going to charge their trustee fee and then they're going to charge their traditional investment, fee. So people say they double dip, but it's two different roles really, which you would pay if you had two different people doing it. But you guys are definitely different in that respect.
yeah.
So all those other things you mentioned too, you're saying those are included in your fee, the tax prep and
The investment, the record keeping, I didn't mean to interrupt you, Letty, but the administration responsibilities, whether it's an estate or trust administration, and as Letty said, the individual trustee likely won't have the benefit of having a Letty, an in-house
Right.
attorney who's at a partner level, at portfolio managers and other professionals that a corporate fiduciary such as fiduciary trust has on staff. And so we have experts, they're experienced, they're personable, they're proficient, and they're available when you need them.
That's amazing. Yeah. Let me look at the chat here because we have lots of posts. Let me see if we have any questions we need to answer. Let's see. Can you guys see the chat as well? I think you can, right? I'm designated as the first trustee of Mom's Trust and also currently designated acting as her POA. I know there must be an accounting of all assets to all beneficiaries when she passes, and I assume the role of trustee. But am I obligated to divulge her estate's assets before she passes? One beneficiary is very confrontational, has emotional issues, and potentially poses issues down the line, already demanding to know what his future inheritance looks like. So we don't want to answer
lives here.
Yeah, right.
What we do with every day.
We don't want to be too specific about things. Do either one of you want to address that in a high level? I'm happy to jump in as well if you'd like.
You can start, Samantha. That's fine.
So the two things are definitely different roles: the power of attorney and the trust. Under the trust, if you're acting as trustee for Mom, so you're the first designated, so you're not the current trustee, I don't think. So I think Mom is still her own trustee from what I'm gathering there. So definitely there's no obligation to anybody until Mom passes away. Mom's alive. All your duties right now are to her because she's alive. Under the POA, it's to her. And even if you were serving as trustee, if Mom is still alive, your only duty is to Mom. The trust is revocable until she dies. With that said, though, you can't go stealing Mom's assets or, using the POA to invest in bad things, which will eventually harm your siblings, but they're not entitled to know all of her assets right now. You guys want to add anything in there?
Yeah, and it seemed like, you don't have any obligation to Mom now because Mom can always change her documents as long as she's alive.
Yeah.
So assuming it's not an irrevocable trust, I would just add, she can always change it.
Right. Yeah. So there's no inheritance rights per se, right? Just because Mom has a trust that says everything goes to all her kids equally today, they're not entitled to anything because she might change that document.
Mm-hmm.
I am the trustee of a trust that was originally drawn up for my grandmother, the grantor. Upon her death, the trust was transferred into a spendthrift trust with my father and stepmother as beneficiaries. My father has died, and I am now in charge of the estate in which my stepmother can live to her death. Upon her death, the trust is to be dissolved and liquidated and divided between the 5 children. The lawyer that drew up the trust said it was an irrevocable discretionary trust. I'm not sure what your question is. So if you want to add something to that, but when somebody dies, their trust becomes irrevocable. So I don't know if that was the question. Let's see. I just wanted to know if I was liable for anything as long as I act in the best interests of the beneficiary and the estate itself. That's a tough one. So best interest can be interpreted different ways, right? What one person thinks is the best interest, somebody else doesn't, and the court might agree or disagree. So, damned if you do, damned if you don't. Sometimes, you make a distribution, you get sued. You withhold a distribution, you get sued. That's a tough one, which is why working with a corporate trustee, either they're the main trustee or they're a co-trustee, it's really great, or acting as an agent evenly. It's great to have the guidance of a professional because how does a regular person determine what is in the best interest of everyone, right?
And I think the key there, Samantha, is again transparency and disclosure, because under Florida law, if you disclose properly with the proper language and the proper notice, they have 6 months to object, or forever hold your peace. So that's the way that you can get some comfort. But again, it has to be proper disclosure. You have to make sure you're disclosing the right information. You have, so it's if you have a professional on your side, these are the type of things that they would make sure that you're doing.
Exactly. Yeah. That disclosure notice is
Mhm.
key, super important, because you could take, perhaps sometimes the statute of limitations are different, but you could take something that might be a 4-year statute of limitations down to 6 months.
Right.
And that's huge. That's huge. What is the minimum amount in the trust estate you'd require before you get involved? Great question. So does fiduciary trust have a minimum?
Matt, you want to?
Go ahead, Letty. I'll let you start.
So typically our minimum client size is 5 million. That's, we would also take less depending on the circumstances, but our typical minimum is 5 billion.
And that would mean all assets, even if it was real estate or just investable assets.
Typically, we use our typical trust size does have minimum 5 million investable assets, but we certainly can work if they're not all investable assets. We certainly can work with the client. We can maybe charge a small fee for the other assets so that we can take on the opportunity. I mean, we really do try to work with our clients. We try not, fees to not be an issue. So the individual, every trust is different. And the fee structure for every trust is different. But just so you have an idea, I would say, our typical minimum trust size is 5 million, not necessarily all investable assets. Matt, do you think that's a good?
I think that's a great answer and a response. And, again, it's stay organized, have a prudent investment strategy, and consider a corporate trustee for these complexities, these nuances. If the trust becomes too complex, hiring a corporate trustee, whether it's fiduciary trust, can relieve the burden and ensure compliance, because we handle the administration, the investments, the communication, and protect you from personal liability.
Yeah, and if you've been named as trustee and a corporate trustee hasn't been designated, we can look to the terms of the trust to see you might have the ability to appoint a co-trustee to serve with you.
That's right.
If not, you could get beneficiary consent, or worst case scenario, you could go to court. You could petition the court for permission, to add a co-trustee. When you are the grantor and you're creating the trust, you should consider putting some language in, perhaps, and choosing a corporate trustee, or adding that language in and giving we do that a lot, where we give our designated individual trustees the ability to add a corporate trustee or a co-trustee. Under our handouts, there are lots of great handouts. Aside from their profiles, there's a handout, the benefits of a professional trustee, tips on selecting a professional corporate trustee, a list of Fiduciary Trust International's trustee services, and then, of course, the trustee responsibilities.
I like the one that's selecting a trustee, corporate or individual, because it gives you a side bar, and it goes through all the responsibilities that you have to think about versus a corporate trustee. So take a look at that. Encourage you to ask questions, and feel free to reach out to Samantha. We're happy to continue those conversations when it's appropriate.
Yeah, it's a really important decision on choosing the right person, because they can really wreak havoc. And unfortunately, I know there were several questions on, but if I do the right thing, am I okay? I have a client right now. I did not draft the trust, helping with the administration of the trust. He happens to be a lawyer in a different state, so nobody knows him. And he's getting sued by the beneficiary of the trust. And when he first contacted me to help him, not with the litigation part, but the administration, I thought, oh, this sounds crazy. This just sounds crazy. He's done a lot of bad stuff, and this just sounds crazy. I wasn't even going to take the case. And then I kind of felt bad for him. I talked to him more and I felt bad. And then when I really dived into it and learned everything that had happened, I realized he didn't do anything wrong, right? His client, he's a transactional lawyer, but not a trust and estates lawyer. So this is not his area of expertise. He was named by his own client in the guy's trust. The guy dies, so this lawyer steps in and he's trying to do the right thing. And I think he did a pretty good job with some complex, there were businesses, there was commercial real estate, there was an ex-wife, there was a lot of complicated stuff going on, business valuations, tax returns. And the beneficiary, he hired legal counsel like he was supposed to. He hired a big accounting firm to prepare tax returns. He got some really, really bad representation and advice and ended up getting sued. And he is being taken to the cleaners. Then there's this thing. Normally you get your trustee, you get sued, you hire a lawyer and you pay that lawyer out of the assets of the trust until you get a notice from the plaintiff saying, don't use any of these assets to pay your lawyer. You can have a hearing on that, but they can prevent you from paying for your legal defense out of the trust assets, which means you're paying for it yourself. And that can be very, very costly, even if you didn't do anything wrong.
And
Yeah.
Samantha, the time and aggravation that goes into this.
Terrible. Yeah. Really,
Yeah.
really. I mean, it's traumatizing. Time is money. It's really bad. So, you know, if a corporate trustee were involved in that, for sure, it just would not have happened.
Yeah, I think a corporate trustee is really equipped to avoid that type of liability and carries insurance for further protection. We have deep pockets, certainly, but we have, in addition, bookkeeping systems to ensure that meticulous accounting, that transparency,
Yeah.
to provide accurate reporting to beneficiaries and to tax authorities. So, as you said, Samantha, even if that individual trustee is acting in good faith, they are personally liable for the unintentional conduct that fails short of the legal standards. So consider a corporate.
Yeah, it's definitely a risky and scary endeavor. Now, I don't want to scare all my clients out there because we need to be able to appoint trustees. So somebody's got to serve. And not everybody has $5 million. But you just need to be careful. And that's the whole point of this webinar, is to, discuss some best practices. I know we kind of talked about and touched upon it, but I want to make it clear that at least under Florida law and probably in every state, the beneficiaries are entitled to an annual accounting. And this is probably maybe the number one reason why trustees get sued, is they don't provide this financial disclosure. But an annual accounting is required, and that needs to show what the assets are, what their values are, what income came in, what expenses were paid, what distributions were made. The beneficiaries have a right to stay informed, not every single day necessarily, but they have legal rights to be informed, kept informed. But the more you communicate, like Letty and Matt said, the more you communicate, the fewer problems you're going to have, and you're going to head them off in the past before they even become bigger problems and costly problems. So any other quick questions? It's 7:00. If not, I appreciate everybody coming. I hope you enjoyed this and got some value from this. It is recorded, so if you want to watch it again and pick up some more tips and take notes, it'll be on our YouTube channel. Thank you, Matt and Letty, so much for your time and for spending your evening with us talking about trust. I think it's exciting. I don't know if everybody does.
Before we end the session, I want to choose the winner for the raffle.
Oh, yes.
Stay until the end.
Very exciting. Very exciting.
Screen. Okay, spin the wheel, and this is everyone that stayed on until the end of this webinar. And the prize is a 3-month subscription to Fruit or Wine, and the winner gets to choose. Here we go.
Congratulations, Thomas.
I'll be reaching out after this, Thomas, about how to claim your prize. Congrats.
Thanks, everybody. Appreciate your time.
Thank you,
Good
Samantha.
evening.
Have a great evening.
Bye.